Darren Ravel from Collect TV, joined by Paul Lesko of Lesko Law. Paul, you have shook the hobby up today with the announcement of 15 filings, arbitration filings against Whatnot, among other things, saying that they are an illegal online casino and they are essentially violating gambling law associated with the state of California, which is the state that they choose to allow their user agreements to correspond to. So let's go through all of this. I guess I'm going to start with their arbitration happens because the user agreement stipulates it cannot be a lawsuit, that you have to go along with what they say. So tell us how this all came about because they are extensive filings with extensive allegations.
Yeah, so right around the time of the National this year, I was approached by a number of buyers on Whatnot that had lost significant amounts of money in the millions of dollars on Whatnot. They initially went to the platform wanting to buy cards, but found themselves, caught up in this casino-like atmosphere that they had. And next thing they know, they're, spending money hand over fist. They don't have any control over it too, because it's a very addictive platform. And that's, kind of where we started to look at the case. It's kind of a three-part case, if you want to look at it that way. Our first part is that the way that randomized breaks and repack breaks are run on Whatnot appears to violate contest sweepstakes gambling laws. The second portion is that Whatnot knowingly operates a addictive platform without sufficient safeguards and controls. And they're basically making money off of dopamine rather than actually selling cards. And the third part is it's kind of intertwined, but because Whatnot is operating without the regulations or the controls that a regulated casino would have, the ability for their breakers to commit fraud, to engage in breaks that are just not right, skyrockets. And that's what we provide evidence of in our complaint, is that, here's, the way that they run their repack breaks, the way that they run their randomized breaks, it's gambling. We provide evidence of fraud that has occurred during breaks. And then also the fact that our clients, have addiction issues, have tried to get off the platform. There aren't safeguards such as the ability for self-banning or meaningful spending limitations to the point that, these are things that are required by online casinos but are not available on the Whatnot platform.
Now, let's get this out of the way. Whatnot has rejected this notion. They do say that they understand that gambling is illegal and it's not allowed on the platform. That it's not a game of chance, that everyone knows who's buying into these breaks, what they're doing, and assuming that they get something back. So if they buy the Charlotte Hornets to try to get Con Knipple, that if they don't get any Hornets out of that break, they will get something. At least from what your experience is, tell me why that would not be true.
Sure. So with Whatnot randomized breaks, you're not buying cards. You're buying a spot. You're buying a spot that gives you a chance to get after a wheel spin or a dice roll or through a little card, drawing of cards, you have a chance of getting a team, not necessarily the team you even want. So that's where the chance comes in, because under contest lottery sweepstake laws, you need three things. You need chance, you need a prize, and you need consideration. Consideration, that's easy. That's just, you just pay to go into a break. That's easily accomplished. A prize, well, the prizes are there. You can see them all the time in breaks where they tell you what the chase card, what the chase card's value is. They tell you what the ceiling is. So they are telling you what the prize is. And the determination here is it's solely by chance. It's like if you went to the grocery store and you wanted to buy a turkey, you get there, they spin a wheel, and you leave with broccoli. That's not how it's supposed to work. I mean, there's completely chance in what the end result is. Because of that, it's supposed to be regulated like a casino, and there's supposed to be controls on them. And that's
Wait, hold on,
where,
hold on.
sure.
So what happens if Whatnot says, well, there are not controls because the California State Gaming Board, by the way, they're one of the few states that still does not allow sports gambling, right? And so the state that we have chosen, uh, by the way, I guess you could say they are regulating that by not allowing it. But the state that we have chosen, just they haven't chose to regulate us. And so why would we be responsible to regulate ourselves if the state law doesn't provide that, at least in cards, that we do this? In fact, our hobby is not regulated, and you could, for all time, say that this might be a game of chance. Every pack opening is a chance.
Now, so there's two responses to that. One is if you have a wheel, if you're spinning the wheel in a transaction, if you have anything that looks like you're at a casino, you're at a casino. And just because you're selling sports cards, you're saying you're selling sports cards, that doesn't mean that you're actually doing it. I would like for Whatnot to point out a legitimate transaction that starts with a wheel spin, where the result is a spin of a wheel. That's gambling, and that's the reason nobody does that. It's gambling.
You talked about the provision of you can't stop. Doesn't Whatnot allow you to set some controls?
So we started talking to Whatnot in October, and soon after talking, we asked them to do a number of things, including implementing spending limits, the ability to self-ban. They did implement, I mean, to their credit, they did try to implement some spending limits. However, they're toothless because you can actually change the spending limits. So long as you don't exceed it, you can always bump it up. So that's not a viable spending limit because, as you probably would recognize, somebody with gambling impulse controls, when they get close and they're in a spiral, they will be able to just go in, change it, and keep on going there. It's a toothless control. But then the ability for self-banning is what we're really focusing on, because some of our clients, and in our complaint we have this, we have had clients who've told breakers, ban me, lose my number, stop contacting me. And instead of that actually happening, the breakers send them coupons. Come on back, we'll give you $1,000. Keep on coming back. So there aren't those controls, and that's why part of our argument is Whatnot is making money off of dopamine more than anything else. Because if you have people who need help, who want off the app, they should be able to get off the app without having to beg for it, and then have breakers, DM them, hey, here's $2,000, come on back.
We live in this dopamine world, and there are more ways to get dopamine. So the question is, does that mean that we have to step up our banning everywhere? Prediction markets are somehow not regulated by sports gambling laws. Um, and so there is some sort of potential catch up here. What happens if Whatnot were to say, we're living in the society that we live in right now, and we didn't do this.
Yeah, that's why the arbitration proceedings are going to be for, because we don't think there. I mean, if you just watch any of these breaks where they start off with a carnival atmosphere and a wheel spin and people yelling jackpot baby jackpot, that's not a transaction, that's gambling. So Whatnot can try and frame it in any way that they want, but you're not buying cards, you're buying a spot with a chance to get a team. And that's gambling. It's chance, luck, or you got chance, you got consideration, and you got a prize. And that's all we need to show gambling.
So you're saying a defense that is, well, every time you open up a pack of cards, it's chance. Technically, I don't know. I mean, if that's the defense, you're saying, well, if it walks like a duck and talks like a duck, it must be a duck.
Now, the trading cards are different, though. So trading cards do have your odds on there. They also have a no purchase necessary option. No purchase necessary option is on cards to get rid of the consideration requirement. You can always send in a no purchase necessary option to trading card companies, and they will give you the same odds, and you potentially will get a chase card from there. So that's how, part of the way trading card companies ensure that they don't fall into this contest sweepstakes area. They
But if I don't
eliminate.
get the team, let's say I don't get the team, right? I got a team. I did not get the player in the pack. Do I get something?
Well, that's different. So when you're buying the cards, when you're buying a pack of cards, you're actually asking for a pack of, you're getting a pack of cards there. When you go to buy into a repack break, if you want I'm buying in because what do I want? Solely what I want here is the Spurs. That's all I want. Okay, wheel spin, chance. No, you get the Wizards. Well, that's not the transaction you're in. You can either buy baseball cards or not, or you can go somewhere else and specifically target what you want.
But
However,
if I got the Wizards, if I got something, does that get around the sweepstakes laws?
it does not, because you have varying values. So so if there's a prize, that means there's something worth more than anything else. There's something that everybody is targeting there. That's what, everyone's looking for the ceiling. If you look at the way that they're marketing breaks now, the ceiling for this is $16,000, $18,000. What does everybody want? They want that $16,000, that $16,000 card, that $18,000 card. They're targeting the prize there. And so again, prize, consideration, chance.
Whatnot said in their response today that 4% of their sellers are breakers. Do you have any idea what percentage of their revenue it is?
No, I don't, but it's got to be significant because our clients, some of our clients have lost millions of dollars, and they're not aberrations. So there's a lot of money here, but I do not know the exact numbers.
And the people who say, well, it's on them. Yes, they might be addicted, but they had to know. Why is that not a defense here?
It's just like an online casino. If you're on an online casino, they do have the safeguards to protect people who do have gambling impulse controls. You can set spending limits. You can be self-banned, and that's the important one. It's not just hey, ban me, and I'll just set up a new email address. It's some type of IP address, credit card, geolocation fence that they can put on and ban you from that. There are certain states that require you can register with certain states and say, I want to be banned from all casinos. And then that works. They will not, no casino will actually do business with you. So there's
What about deleting an account? Has any one of your clients asked Whatnot to delete their account?
they've asked for the accounts to be deleted. And in some instances, it doesn't work. And in other instances, they just go back and set up another account. New email, different credit card. This is just another way to get in. But for the most part, I mean, the ability for self-banning is not an option at Whatnot. You can't go anywhere on their website and find, hey, I need to be self-banned from here. It's not an option.
What do you think is the timeline now of let's take people through what will happen? Again, people are used to lawsuits. This is arbitration. And we should note that you are making this public today and have made your entire filing, which again has been filed on behalf of 15 Whatnot customers. You've made it public. Normally, arbitrations are not public. Let's start with why you've made it public.
So part of the reason we're making it public is because Whatnot has changed their arbitration agreement. So typically for an arbitration agreement, what happens there is you as a consumer are giving up your right to go to court. You can, for any other, if you're ever harmed and you don't have an arbitration agreement, you can go to court, pay the filing fee, you get a judge for free, you get the judge's staff for free, you get all your time in court for free because your taxes pay for that. However, the deal is because you're in court, it's public money that pays for it. The public gets to know what's going on. Arbitration proceedings are kind of the opposite. Corporations do not like their issues litigated in the court of public opinion. So an arbitration is a secretive proceeding. However, since it's a private company, somebody has to pay for the arbitrator and their staff's time. Normally, what happens is the company that has the consumer, opting into the arbitration provision, the company pays for the arbitrator's time. That's how Whatnot's arbitration agreement worked until March. Well, in March, they changed the arbitration agreement, we think, in view of us contacting them and trying to work it out. And now they want to split the fees with the consumer. That is going to be a very big hindrance to certain people who have smaller claims. By smaller, I mean, I don't even mean a small claim. A $50,000 claim is not a small claim, but that will get eaten up in arbitration fees alone. So the reason we're bringing it up is because although I think Whatnot's arbitration provision is unlawful and will be shot down, they did offer a 30-day opt-out period. So we're bringing this out so that people are aware of the opt-out period. And really, I couldn't care less if you want to join our case or whatever it is. If you ever think you might be harmed at whatnot or something might go wrong, look at the arbitration provisions. Look at both of them, get a lawyer to look at them both, and make an educated decision about, do I want to go into this new arbitration provision or do I want to go into the old one? Because it's our view that this new arbitration provision with the 30-day opt-out period, whatnot put it into place to minimize the number of people that could sue them for the reason that we did. To actually put a hard cap on, okay, once we get to April 4th, nobody else is going to be added to this, added to these cases, because a plaintiff's attorney or a plaintiff's firm or the plaintiff will have to pay their own way through the arbitration.
Got it. Now, this then goes through the American Arbitration Association, the AAA,
Correct.
and then this could take like a lawsuit 18 to 24 months for a resolution. And then what happens on the resolution? Are arbitrated awards precedent setting or not?
Not the way that Whatnot has it set up. Each case, there's also a class action waiver. So every case will live and die on its own. They do have we are also seeking an injunction for, changes to the Whatnot platform. We can get injunctions in arbitration solely focused on our clients. But then the next step would be, if we want that applied across the board, then we need to file a lawsuit afterwards. So it's one of the, it's normally you get it all dealt with right at the beginning, but here that would be a continuation that we would need. If we want to if Whatnot's not going to make changes to their platform, if we win our cases and we want them to make changes, we will need to file for the next step for injunctions.
It's been only a couple hours, but given early reaction, how do you feel about going public and the filings in specific?
I think it's a good thing, because I've had a couple people reach out to me wanting to know more about the opting out process, and that's really what we want to do. Because I'm a plaintiff's attorney. I mean, I started off my life as a defense attorney, but I'm a plaintiff's attorney now, and I hate arbitrations. They're the worst. It's the way that companies can hide stuff. And when I see an arbitration agreement like this come in, that's even worse than most of the ones I've ever seen. I want to educate people so they know about this. So from the context solely of people becoming aware of maybe there's steps I might want to take in view of the arbitration agreement, I think it's been a success.
Paul, the fact that it's arbitration and not necessarily a lawsuit, or it's not an attorney general, how much does that slow down potentially the progress of what could happen if these claims were to be affirmed?
It definitely slows it down, because had we filed in court, we could seek an injunction. Because again, we're not just seeking damages, we're seeking an injunction so that Whatnot would make substantive changes to protect consumers. If we were in court, everything is dealt with all at once. Here, however, we have to go through the entire arbitration process, which 12 to 18 months, on a normal or fast side. And then if we want to have the injunction apply, then we go to court. So it definitely slows it down. If an attorney general was looking at this, they can do it much quicker too, because again, that would be in court. So the arbitration process does slow things down fairly significantly.
Whatnot is obviously not a small company. I think 8 billion in revenue, valued at $11 billion at their last raise in October. You'd think they have a lot of lawyers looking at this. It seems like you explain it like it's obvious. Um, they are not going to talk to us on camera, but what how could it be so obvious with the gaming and the do you know anything about have they done any sort of education from their breakers about what not to do to make it look like a casino?
They have some prohibitions, but I mean, one of their prohibitions is that you can't have wheel spins for prizes. I mean, it says that in their terms of service. You can't have wheel spins for prizes. Yet here you have them in randomized breaks. You have a wheel spin. They do have,
Commonly, is it a common practice, the wheel spins?
yes, either the wheel spin, the use of cards that have teams on them, or rolling dice. Those are for randomized breaks. Those are very common. Um, Geez, I lost my train of thought there. What was your question? I'm sorry about that.
You would think that given how big they are, that they and we don't know how big their revenues are. in terms of just the breaks. But you would think that it would be a significant liability to their business as they raise on $11 billion valuation. Again, how could it be so obvious then that this is gambling? Of course, they say it's not, but to you, it seems to have the easily identifiable characteristics of gambling.
Yeah, no, I've thought in 2011 or 2012, I interviewed a rather smart individual, Dale Jerling, who was a contest sweepstakes lawyer. And at that time, we came up with, he said that he thought, there are very serious concerns with some types of breaks. And it's not that well known really out there. So I think what you have is you have an internet.com company that started to do something without due diligence on it. And then all of a sudden it becomes a significant part of your business. And then at that point, it's, well, justification for what you're doing or changing the practice. I imagine they make a lot of money on these randomized breaks. I bet when they started doing it, I'd be willing to bet that they did not even consider whether they were legal or not. And now that they're entrenched, well, what are you going to do? But to go with what you said about advising, in our complaint, we do provide an example where a breaker did go to Whatnot, asked for an explanation of what would be a break that does not violate Whatnot's rules, is actually a viable break. And Whatnot basically responded, use your best interpretation. They did not provide guidance.
Is there anything I didn't ask you that you would want to say about this?
I mean, I think just to reiterate, the main focus is the arbitration agreement. I want collectors out there or people that use Whatnot. Again, no matter what you do in the future, whether you feel like you've been harmed by Whatnot or not, really focus on that arbitration agreement. Look at it. Decide, do you want to be stuck with that? Because after April 4th, the only way to get out of it is to have an arbitrator say that it's not viable. So you can't even challenge it in court. You have to challenge it in front of an arbitration system. So I would just ask for Whatnot users, look at the two arbitration agreements, decide which one you want, and act before they act for you.
How much of a slam dunk case is this for you, do you think?
As a plaintiff's attorney, you can never say it, but as a plaintiff's attorney, I mean, these are cases we take on a contingency basis. We don't take cases we think we're going to lose.
Paul Lesko of Lesko Law, thanks for joining us to talk about the Whatnot arbitration filings.
No, thanks for having me on.